Hi, my name is Melanie Mfume. I'm a private practice attorney. I also work with civil justice and other legal service providers throughout the state of Maryland. And today we're going to talk about the mediation checklist that covers options for resolution that you'll discuss at the foreclosure mediation. The first section is going to cover home retention options, and home retention means that you're going to keep your home. The first option is a refinance. So refinance is a separate loan. So you're going to go to an outside lender, you're going to apply for a loan. If they offer you the loan, you would come back and you're going to pay off the current mortgage that you have right now and go forward with your new refinance loan. Option number 2 is called an over equity refinance. So if you are upside down in your loan, so you owe more on your property than what your property is worth, then that means essentially you are getting a refinance loan to pay off your current loan, but your current lender is agreeing to accept less than what's total amount that's due. Sometimes we call this a short payoff. If you are familiar with the SUN program may be an example of where you may be able to obtain outside financing, and if you owe more on the loan than what your property is currently worth, and your current lender will agree to accept less, then you would be able to pay off your current loan and be able to stay in the property. Option number 3 is payment in full. That speaks for itself. That means that you are paying off whatever you owe on the loan. You're writing a check for that and paying it off completely. Forbearance is option number 4. Forbearance means that the lender is agreeing to either accept a reduced amount for a period of time or is agreeing to completely suspend all payments for a particular period of time. The important thing to remember about a forbearance is that the lender is not saying that you don't owe the money that you're not paying for that period of time. They're just saying for this brief period that the lender is going to allow you to make the reduced payment or to make no payment, and you're going to be in compliance with the agreement. If you are going to be discussing forbearance with your lender, you need to be sure to remember to ask when those payments that you are making, either not making or making in a reduced amount, when is the rest of that money due? Option number 5 is called a property rent back. This means that you are essentially renting the property from the lender. This is listed under a home retention option. Realistically, it's more of a liquidation option because you're not keeping the home. So if you say, for example, you have children that are in school and this foreclosure or this liquidation agreement were to take place in the middle of the semester and you did not want to have to remove your children from school, you could agree, if your lender was in agreement, to a property rent back that would allow you to remain in the property for a payment of rent through the end of the semester or for a period of time. And the final home retention option is going to be a loan modification. This is the main home retention option that people are looking for. What this modification is that it's changing the terms of your existing mortgage. So it's not a new loan, you're just changing the terms of your existing mortgage. So that would be taking the arrears, you're going to be adding them back into the loan, we call that capitalization. You're going to be changing the interest rate, changing when the loan matures, and then obviously changing the payment amount. And all of those together are considered modifications. Any changes to the terms of the loan, it doesn't have to be all 3 of those options. It could be it could be just capitalization, that could be considered a modification. It could be capitalization and interest rate reduction, and that could be considered a modification. So we just use that term to mean any changes to the term of the existing loan. The other set of options that you're going to be discussing are liquidation option, and liquidation means that you are not keeping the home. The first liquidation option would be a short sale. Short sale means that you are listing the property for sale with a realtor at an amount that's less than what you actually owe on the loan right now. You need to confirm when you're discussing this with your lender if there's anything special that they require. Some lenders want you to have a short sale specialist. Others are fine with you just having a regular realtor. You want to find out what documentation you need to submit to the lender for them to move forward with processing the short sale. The second liquidation option would be a deed in lieu of foreclosure. And essentially what this is an agreement that you will enter into with the lender that you are agreeing to just give the property back to them in lieu of them foreclosing on the property. This will be a written agreement. There are no standard terms of the agreement, so you want to make sure that this is something that you have an attorney review for you to make sure that all considerations that need to be included have been included. Deficiency balance is an issue that sometimes can be included in a deed in lieu, so that if the lender were to agree to waive any deficiency that you may owe them, that may be language that is appropriate to include in this agreement. Third option is cash for keys. Cash for keys is typically something that a purchaser would offer after the foreclosure sale, and really it's just a nominal amount of money, usually $1,500, $2,000 that the purchaser is going to give to the borrower to put toward relocation expenses. We always ask at mediation if this is something that the lender would offer in the event that the lender will offer this before the foreclosure sale, but sometimes the lender will say that they're not willing to discuss cash for keys until after the foreclosure sale. Friendly foreclosure is a new option that has been added to the checklist, and essentially this is a pre-sale agreement similar to a cash for keys, but just a pre-sale agreement that the lender and the borrower would enter into, whereby they're agreeing to the terms of how the foreclosure sale is going to play out. So if the borrower were to request $1,500 in relocation expenses and the lender were to agree, then they would enter into an agreement where the borrower would agree not to contest the foreclosure or to move out at a certain time in exchange for this relocation expense. So really that's kind of a catch-all agreement that the parties can enter into before the foreclosure. Private auction is another option that is available. Really, private auction is you're hiring an auctioneer to auction off your property. We usually see this as being more appropriate if you have an unusual type of residence. So if this is a farm or a waterfront property or a luxury mansion or something to that effect, then it may make more sense for you to hire a private auctioneer and try to auction off the property yourself. And then the final option on the checklist is going to be the structured liquidation agreement. And this again is just kind of a catch-all agreement that the borrower and the lender are going to enter into in agreement, and it kind of can take any shape or structure or form that the parties so agree. And I want to thank you very much for listening to this presentation today, and I wish you all the best.